directed to be personally present before the court on 30th April 2009. This is uncalled for, sir, and this I don't like also. You will not accept defeat and you have come to court of law or to practice. No, I'll continue with the list, Mr. Vasu. Thank you. Let me, I've got to. After 5 minutes, I'm coming back. 13, I have passed an order. I have asked the ELA to be personally present. I have kept the matter on that date. কত তারিখে রাখলাম ওটা? 30th April. To be mentioned there, 30th April to be mentioned. Eight marks. And on his position, 414 grams of brown sugar seized. Your Lordship, I did the report.
But this is the FSL report. My that quantification is not there. Now, my lord, on the last occasion,
Quantification, if it is not there, I can't do anything. It's simple.
My lord, the question was that there are two accused.
Oh, how many contrabands referred?
Two, my lord, heroin and monoacetyl morphine. Total is 414 gram.
Monoacetyl morphine, what is the commercial quantity?
Again, two.
The
question that was, what is the present status? The other accused, he has also been arrested. 2nd of May is for framing of charge.
So after framing of charge, he'll be advocate appearing for the petitioner submits that the petitioner is in custody for 8 months. And the quantum of seizure in the present case is 414 grams of brown sugar. Emphasis has been made on the chemical examiner's report, which reflects that the components were diacetyl morphine and 6 monoacetyl morphine. Learned advocate for the state opposite is the prayer for bail and submits that copies have been supplied and date has been fixed for consideration of charges on 2nd of May 2026. Having considered the aforesaid and relying upon the judgment of the Supreme Court in section Centu State versus State of West Bengal, I'm inclined to release the petitioner on bail, but after the charge is framed, accordingly, the special court will release the petitioner accordingly. The petitioner shall furnish a formatted document. 20-10 local to the section of the learned district, learned special court come additional district judge for court Malda. If on the petitioner shall be physically present on each and every day before all the learned special court on each and every day and not to leave the district of Malda. Last day, the bonds be accepted after the stage of consideration of charges is ruled. If line if the charges for some reason or the other cannot be framed on 2nd of May 2026, London Special Court within a period of 30 days from the date will complete the process. Accordingly, CRAM NDPS 639 of 26 is allowed. I hope no, a court is. Yesterday also the same thing happened. Court is assigned with the determination for bail. So it has either to grant bail or to reject the bail. Now, if circumstances are created for grant of bail, if with spiteful eyes the state or the Union of India points to the judge, then that authority I have got to accept the challenge. We are totally with you. Your Lordship's chair should not be in any manner. Somebody challenges the authority, dignity, and insults the court. I'm not going to tolerate. No, that's. No, we are apologetic. Yes. What is it? 15 what?
The recovery subject matter of this case, 112 bottles of S-cup cough syrup, but from this petition, only 36 bottles were recovered.
Total subject matter 112. 112.
From this petition,
what cough syrup?
No, S-cup cough syrup.
S-cup.
Sir, may I point out one thing, very fairly, the recovery was on the basis of a leading statement of this petition, but not from his point.
How many accused persons?
So total there are many, 5. Yeah, because there are two petitioners, but petitioner has come only
one
petitioner,
petition.
but the recovery was made from on the basis of leading statements of two of them.
How many days you are in custody?
97 days.
Charge sheet submitted?
Not yet.
No, tell them. Come after charge sheet is submitted.
Uh,
I cannot say investigation. Let the investigation be completed. I am granting you liberty after the charge sheet is submitted. The subject matter of the is related to alleged recovery of 112 bottles of Escaf cough syrup. Stop learned advocate submits the ad. There was no recovery from the possession of the present petitioner. And as such, the petitioner may be released on bail. On the other hand, learned advocate for the state opposite is the prayer for bail and submits that the investigation of the case is still in progress. And at the and pursuant to the leading statement of the present petitioner, there were recovery of the contraband. Having considered that the investigation of the case is still in progress, I'm not inclined to release the petitioner on bail. However, the petitioner would be at liberty to renew his prayer for bail after the charge sheet is submitted before the jurisdiction. Accordingly, CRM NDPS number 644 of 2026 is dismissed at this stage. Yes.
And it's 28
kgs of Ganja recovered from shop next to where these petitioners were.
How many days you in custody?
190 days complaint has
Charge sheet
complaint
filed.
being filed, my lord. But this petitioner, one of the petitioners, he has another case pending against him in 2016 NDPS. So he has antecedents.
He's on bail in that case or no?
My lord, that is not. I'll have to take instruction, my lord. I will kindly adjourn it for a day. I'll come back.
Not today.
Obliged.
No recovery from him. When were you arrested? So 7 months. How are you in 1 year, 7 months? Huh? So what is the progress of the case?
So out of 14 witnesses, only one witness has been examined.
Seizure list witnesses examined. Do you come after the seizure list witnesses are examined? Seizure list is at which page?
Page 8 and 9.
But our letters to not to become more direct. Can you take up the matter on Monday? Let's make a election. More direct, far as something.
You were in another case. Shonar is you, huh? What is the name of this petitioner? Petitioner? What is the prosecution case? Seized from your possession.
The process was very good. Apartment, second color trolley bag was recovered. Trolley bag contained 37 kg of Ganja. The officers of the care place, they collected the reserve information.
No, but then you were already arrested. Huh? That is what case?
Slight. I was not arrested. He was not in jail while this case happened. This case was. Then he was traveling, and his implication comes because from that maroon bag, trolley bag, his Aadhaar was also found, as well as a ticket wherein his name was reflected. That those are seizure. And he was arrested. Subsequently, he was arrested in another case. That is also under the NDPS 20B clause 20B / 29. In that case, he was subsequently arrested. Then, in this case,
First arrested.
This case was later arrested as shown arrest. Shown arrest. On the basis of a production warrant, he was produced before the court, and then after being produced before the court, then he was arrested.
Then how was he traveling? No. He was shown arrested.
Later.
So if he was shown arrested later on, so that means
he was outside, while this case was registered, he was not in custody.
registered. Registered.
When this case was registered, when he was traveling on this train, then he was not in custody.
So how do you connect the in the back?
In the back, and his passenger and his ticket was also found, and train tickets has name.
Train tickets are found within the bag.
He left it in a hurry. He left it in a hurry.
Train tickets should be in the pocket of the person. Train tickets must be in the pocket of the person.
Don't have pocket inside process, so they keep it in the bag.
So 1 year, 7 months. Why are you not progressing with the trial? What is the difficulty in progressing?
That is the point that I have to take instructions on that point.
What is the violation according to the judgment?
They are asking 22,000. It can be calculated over High Court. Nobody can be shown that. One thing is known as because after the arrest, you have to be all the procedure. Right to consult is these are hard.
So that opportunity was not granted to you.
Not at all.
Production warrant was issued.
Production warrant was issued. Shown arrest becomes illegal only when he is arrested without being produced before the court. So once if he is produced and then he is arrested, subject to I will learn at the feet of the learned senior counsel.
Your production warrant is over here.
production warrant is not there. I read it in one of the order sheets.
Always.
You are phone arrested, then the court is subject to correction.
Always come up.
A prayer was made for a issuance of production warrant. Pursuant to that prayer I was produced and then I was. I mean,
So after production. You have enclosed all the order sheets. All the order sheets are there since his arrest. 23 থেকে দিয়েছে তো।
Below. But hearing on Monday, it will be better.
Friday not possible. Friday the court will, according to the resolution, there will be time of the court actually. Monday.
Kindly have a look at order number 13, order dated 25th September 2024.
I'm on that only.
Because there it is clearly stated.
I will let him argue. Argument means at the latter hours actually. Latter hours of the day I'll fix. If a matter is fixed, then it becomes difficult. In course of all the bill matters, long matters are difficult. 3:30 on Monday. 3:30. Senior advocate appearing for the petitioner intends to argue on the issue relating to shown arrest of the present petitioner. State opposite is such contention that arrest was pursuant to production warrant. Be that as it may, let the issue addressed before this court be canvassed. As such, bail application be listed under the same heading, fixed at 3:30 p.m. on 27th of April 2026. But you ask your officers 1 year, 7 months, it becomes very difficult, sir, to keep persons going by the trend of the Supreme Court orders. Ratios are not always applicable for bail, sir. 1 year, 7 months, at least 4-5 witnesses are examined. Court can come to a conclusion. On hazy conclusions, we have got to them only on the ground of Article 21 flat. Granting bail is also embarrassing and also reflects the manner in which the proceeding. Seizure list witnesses completed, the complainant completed. You have other police officers whom you want to tender, you can complete those witnesses. And these are burdening in the trial courts on huge quantities where there are seizures. Yes. What is the quantum of seizure? No, what is the quantum of seizure? How many days you are in custody? How many accused persons?
There are 2 accused persons. It must have been included on 26th of June 2025. A person by the name of HON'BLE was arrested pursuant to prior information of the case. It is said that after arrest, he made his statement
that the petitioner was arrested on 6th of November 2020.
No, how these two reports in the same case?
I don't know. You will go back.
Which report?
First from Abdul Malik, second from the petitioner.
Two separate seizures.
Yes. The number of chemical substances.
Seizures were on two different dates.
Okay.
Huh? So how much was seized from you?
From him is 339 point something grams.
Okay. Then he better.
339 grams from him. Huh?
From his house.
From his, whatever it is. 1, 2, 3, 4 contrabands are there. You see? Two reports which belongs to him. That is why you are state council.
Then this I have taken this one, which belongs to him.
When was the seizure? When did the seizure take place? Yes.
On the 12th of November 2025.
And so far as the other seizure is concerned?
26th of June 2025.
ঠিক আছে একটা 19th August. So that date he was not arrested. He was arrested after that November. So there is one test report of December that will be belonging to him only. One for the first accused.
For the first and then
Seizure list dated 6th of November. Seizure list dated 6th of November. Yours?
6th of June 12th of November 2025.
So you were arrested on 6th of November and seizure was on 12th of November.
6th of November 2025 arrest. Seizure pursuant to alleged department of the 12th of November.
there are transactions between these two accused, this petitioner and numerous monetary transactions, UPI transactions, and everything is there.
Both accused, but the fact remains the quantification you have not done over here. Number one. Number two, any criminal antecedents of this?
You can see all NDPS.
So he was on bail. Otherwise, he was arrested. How can he be? Arrest or shown arrest?
This one here, he was arrested, my lord.
So earlier cases are of which year? Yes.
2022,
That must be here on bail time.
maybe on that instruction I know.
Instruction. The petitioner was arrested on 6 November 2025, and thereafter
There are cases of 2025 also.
so he has been arrested in that case.
Instructions.
No, somewhere something is wrong. You say 12th of November, but the letter is 11th of November. Seizure 12th of November. You come to the subsequent seizure list. Chemical examiner's report. মহা ঝামেলায় পড়ে
September. না প্রথম
second one. First one is of September. That is dispatch details. That is of August. Have you got this?
proper instructions.
You see, এইগুলো আগে থেকে ঠিক করে রেখে যে 11 তারিখে চিঠি 12 তারিখে সিজার হয়েছে। See over here, you see this.
Well, I take proper instructions.
Now, you say this, you state councils become angry. Clear case. If Caesar is on 12th, how can you prepare the memo on 11th? Now 12th November, na, this is 11th December. This is ঠিক আছে ঠিক আছে। চার্জশিট সাবমিটেড না কি আছে ওই দেখে আর কি করবো, চারটে কন্ট্রিবিউশন সুপ্রিম কোর্ট দিয়ে দিচ্ছে তো আমি কি করবো। পিটিশনার ইজ ইন কাস্টাডি সিন্স 6th of আমি বললাম কি বললাম আগে, and thereafter he is in custody. Acha, the subject matter as a whole of the KAAs related to alleged recovery of 642 grams of brown sugar. But so far as there are two seizures in the present case, one effected initially, that is 303 grams.
303 grams.
Initially, which was of 303 grams from another accused person. And so far as the present petitioner is concerned, there was alleged recovery of 342 grams. 339 grams of brown sugar. Full stop. There are two chemical examiners report also. The initial report is shown to have been dispatched by the chemical examiner on 19th of September 2025, and the seizure which was effected from the present petitioner was dispatched on 2/3/2026. Full stop. I have considered learned advocate for the state opposite is the prayer for bail and submits that there are antecedents of the present in petitioner. There were telephonic communications between the two accused persons
And series of nuclear transactions.
and monetary transactions বলে দিয়েছে। আচ্ছা, the case was registered on or about 27th of June 2025. Petitioner was arrested almost 5 months after the incident, and after 5 days of custody, the present seizure has been effected. Full stop. The quantum which has been, which the records reflect that the quantum which has quantum of seizure, so far as the present aid petitioner is concerned, is 339 grams of brown sugar. The chemical examiner's report, so far as the contraband which has been seized, reflects diacetyl morphine, 6 monoacetyl morphine, and acetylcholine being present. Having in regard to the quantum of seizure from the present petitioner, and the chemical examiner's report not having been quantified, I am of the opinion that the judgment of the Honorable Supreme Court in Sentusek versus State of West Bengal is applicable in the SLP number is applicable in the present aid case. As such, without entering into the as such, the petitioner is released on bail. Petitioner shall furnish bond of rupees 20,000, which issue 10,000 each, one of whom must be local to the satisfaction of the learned judge, special court Raiganj, Uttar Dinajpur, If on bail, the petitioner shall be physically present on each and every day aid for the learned trial court and shall not or leave the district of Uttar Dinajpur without prior permission of the learned special court. Accordingly, CRM NDPS 664 of 2026 is allowed. Report submitted with report to na chemical examiner's report. Past report was perfect. That wouldn't have any other benefit to that. There were two uh, Raj framed. Teaser list page 19. Page 39, na? You are who, Saidul? Chemical examiner? দুটো আছে 303 is the 303 subject matter of the case 303 grams তো দুটো আছে তো charge framed so the same principle will apply. Petitioner is in custody for 7 months. The subject matter of recovery in the present case is 303 grams of heroin. Learned advocate submits that the chemical examiner's report do not quantify the contrabands which are reflected in the report being 6 monoacetyl morphine and 6 and diacetyl morphine. Full stop. এভাবে লিখে কেন হেরোইন বলে দিতে পারে তো তাহলেই তো হয়ে যায় having as a learned advocate for the state opposes the for bill and submits that charge sheet has been submitted and charges have already been in framed. Full stop. Petitioner is in custody for 7 months. There are 2 contrabands which has been referred to in the chemical examiner's report and no quantification has having been done. The judgment end of the Supreme Court in said to say AA versus State of West Bengal is applicable to the facts of the present case. As such, the prayer for bail of the petitioner is allowed. Petitioner shall petitioner shall furnish bond of prayer for bail allowed. Petitioner shall furnish bond of rupees 20,000 with 2 surety AAs of rupees 10,000 each, one of whom must be local to the satisfaction of the learned additional district and session judge. Second court come judge, special court, NDPS Act, Berapur, Murshidabad. If on bail, petitioner shall be physically present on each and every day before the learned aid trial court and shall not only leave the district of Murshidabad without prior permission of the special court. Accordingly, CRM NDPS 669 of 2026 is allowed. Just
Number 20.
yes.
From this one, next one,
मतलब एयर कस्टम्स मतलब Bangkok
Intermediate.
intermediary all same quantity.
Okay, in view of the seizure effected aid at the Calcutta airport, কোথাকার লোক?
They are Bihar, Krishna Kumar, Bihar, Bhagalpur, Patna.
পাটনা এয়ারপোর্টে নামতে পারতেন কি বললাম and similar matter and intercepted by the air customs authority and similar matters being fixed in the monthly list of May 2026. Let the matter appear in the monthly list under the same heading. So,
Great.
0.039 grams of Ganja was found from the possession of one Akash Ashok Sharma. From one Akash Ashok Sharma.
But over here, Malat, we need to consider the prosecution complaint, which because 60 days is over, Malat, it has been filed. Malat,
I just coming, I just did like what I was recording passenger. He indicated towards me of his position of his Ganja was recovered and I was also arrested.
he was the main person. This person indicated him. It will appear at page 7 of the remand application.
international flight or
International, both.
এই জামনগরের লোক কলকাতায় আসছে কেন?
Malat, Gujarat.
We've seen that. That's why I'm asking. Coming from Thailand. Thailand. ওই মান্থলি সব ইয়ে করে দাও হ্যাঁ তো মান্থলি সব মে 2000 ওই একই আগে যেটা করে ওই একই এয়ার কাস্টমস তো
Malat, over here, the recovery, Malat, that should be deleted. There is no direct
কি বলে
recovery.
রিকভারি বলেছি রিকভারি
তাহলে ঠিক।
সিমিলার ম্যাটার্স
Yes,
আছে
Great.
চলো নেক্সট
22.
ইয়েস ওকে টোটাল সিজার হাউ মাচ টেল মি লো
My lord, initially 1505 grams of heroin was seized.
টোটাল কত
My lord, subsequently on the statement of the person who was arrested, two more seizures were there. One 447 gram and another 405 grams. From this present petitioner, 447 grams of seizure was made.
টোটাল
Total about 2.5 kg. But the problem is that the initial seizure of 1505 grams, my lord, nothing was recovered. But the subsequent seizure,
contraband is there
contrabands,
কি রিপোর্ট
no, my lord, I must be candid, my lord, kindly cease. The problem is that there are two separate seizures subsequently. We have the report of one seizure and the report of the another seizure is not in the charge sheet. So far as the present petitioner's seizure, the FSL report is not in the charge sheet.
চার্জশিট সাবমিটেড
Charge sheet submitted. Just now, sir, about a few days back.
কি দিচ্ছে কি
This is in respect of that, saying that no contraband.
No, I am
That he has
admitting
admitted.
that. I'm admitting.
নট টুডে সর
What, my
কার লিস্টে থাক টাইম চেয়ে নেবে কাউকে দিয়ে।
23.
Who is you are there 23 not today Kipa junior
24.
My lord, I have instructed that when one of the activities we have been charged of by you, For this petition is concerned.
What is the quantum contraband?
But that is 256 kilograms of Ganja. I have nothing to say about the quantum of these materials are concerned. But kindly see what is the participant. This petitioner was apprehended on the basis of a source responsibility. He was asked to come to the police station. Did my lord give
Charge sheet submitted?
my lord, no statement recorded so far is concerned. No
হ্যাঁ তাই তো আমার মনে হচ্ছে কামা
no statement which is otherwise connecting me.
হাউ ডু ইউ নো
My lord, kindly see.
আরে
It is a letter of competence. My lord, I have annexed a letter of competence. Kindly see.
that in course of investigation will come. You don't have the copies. How are you going to say?
My lord, kindly see how I have been apprehended. But it is their letter of complaint. Source information, I was asked the police to attend the police station. Then he says, fine, we will know what it is. They says, I have said fine from this truck, so this is coming from here. So this is carrying this quantum of money. And this person they are carrying. Thereafter, they took me there. They just
আচ্ছা আচ্ছা আফটার আফটার দ্য 256 কেজি সিজার হয়ে গেছে এগুলো মাইন্ড এখন 296 আরে আই উইল কনসিডার আফটার দ্য
Not on the basis of the leading statement of this petitioner, my lord, these 96 was recovered.
leading statement.
after the charge is summoned না 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 পেন্ডিং রাখছি I have rejected already. Or as a principal, I am not granting in course of the investigation. I am telling you. আরে লিডিং স্টেটমেন্ট বলছো সোর্স ইনফরমার নাকি ও ফাঁসিয়ে দিয়েছিল advocate appearing aiming for the petitioner submits that there has been no recovery from the present in petitioner and the petitioner has been implicated on the basis of statement of
No, there is no statement.
The principal accused.
When it was recorded.
And unnecessarily and falsely he has been implicated in connection with the incident case and is in custody for about 84 days. Learned advocate aid for the state submits that petitioner it is a petitioner from whom the case emerged. His investigation and the investigation of the case is still under progress. Having considered that the investigation is in progress and there has been in alleged recovery of 296 kgs of he said 96 296 kgs of Ganja. I'm not inclined to accede to the prayer advanced by the petitioner. At this stage, petitioner will renew his prayer for bill at a subsequent stage. Accordingly, CRM NDPS 698 of 2026 is dismissed. Why?
The rejection of the
In November,
Matter was rejected by my lord on 19/11/2025.
Total seizure is how much?
Total seizure is 216.
147 bottles.
My lord asked order for completion of the trial within 3 months. Thereafter also.
Charge framed when?
Charge framed, my lord, on 7/2/25.
11 dates for evidence. For a single date
Chemical examination office expert was the PW1, my lord. He has not been turning up. We made prayer that we will examine him virtually. That prayer was allowed. Still, he did not turn up, my lord. And then thereafter,
The subsequent witnesses you could have produced.
that direction, my lord, I gave. That was not done.
for 11 days. No witness.
Court is there now.
What is that?
And
Last occasion.
My lord was that the evidence will take place even in presence of the judge in charge. But that also was.
All right, seizure list witnesses you examine. Who are the seizure list? Independent or the police? Yes. Oh, yeah. Well. The subject matter of the case related to alleged recovery of 2147 bottles of fencidil and bottles of fencidil. Petitioner was arrested on or about 6/3/2024, and since then he is in custody. Charges have been framed on 7/2/2025. Until date, not even a single witness has been examined. Full stop. The earlier order dated 19/11/2025.
Only PW3, my lord, is the independent and one more police witness to the seizure.
ठीक है इसमें. Examine the witness.
PW3.
Two seizure list witnesses.
Two seizure list.
Replay X, there was a direction on to complete the prosecution witnesses within 3 months from the next date fixed. Full stop. अच्छा till the अच्छा there has been huge recovery of contraband in the present case. As such, one more opportunity is granted to the prosecution to only complete the seizure list witnesses within a period of 60 days. Full stop. If after examination of the seizure list witnesses, the learned trial court is of the opinion that the case has been diluted, in that case, the learned trial court on an application filed by the petitioner will consider the same leniently in favor of the accused. Sure. With the aforesaid observation, CRM NDPS 713 of 2026 is disposed of. Report submitted by the state be kept with the record. Sorry. Not, you are there. 26.
Sir, page 3 1. There is a direction paragraph here. Not paragraph. I was the trying to decide. Get up here. One custody, 1 year 6 months.
What is a seizure?
101.3 and plus one is 15 kgs of acetic anhydride.
अरे बाबा एसिटिक एनाइड्रेट माने तो ये हेरोइन माने. How many days you are in custody?
I am in custody 1 year 6 months.
My lord, first IO is going on. Second IO is
तो हो गया चित्तन.
yes, your lordship. Next date is on 2nd of June.
How two more witnesses?
4 witness. Seizure list witness has been examined.
Bill দেওয়া যায়. Bill নিয়ে বা কি করবে? Acquittal নিয়ে বেরিয়ে আসবে. London advocate 8 appearing for the petitioner submit that petitioner is in custody for more than 1 year 7 months, and the earlier directions of the court reflect that there was a direction to complete the prosecution witnesses by 31st of March 2026. Full stop. In the meantime, there were issues relating to administrative assignments upon the judicial officers. As such, the trial could not be completed. However, submission of the learned advocate for the state as also the report reflects that the case is at the advanced stage and the first investigating officer is being examined by the prosecution. Full stop. Taking into account the overall circumstances and the fact that the case is at the advanced stage, I am not inclined to release the petitioner on bail. However, the learned trial court would put in efforts so that evidence, so that the examination of the accused under section 313 is completed by 30th June 2026. 313 complete. With the procedural CRM NDPS 721/26 is dismissed at this stage. Report submitted. We kept with the report. Huh? This is after this is I will get anybody.
Yes.
Huh? ठीक है. Huh? You will appear for the state in every matter. one day 150 matters state advocates did not appear continuously. He has said that 120 ফাইলটা একটু আমায় পাঠিয়ে দেবেন, হ্যাঁ? আরম্ভ হয়ে গেলে এবার একটু অ্যাপ্লাই করবো না। ইয়েস, কি হয়েছে?
Out of three minors who are facing trial, one is on a absolutely other not being dead. But one thing minor is charging minor, contributor of the examination. What is that thing? My opinion is
How many days you are in custody? Charge frame or no?
charge for them because of that matter.
This is again a problem becoming, in spite of the legislature saying that you proceed, trial in absentia being incorporated, that is not being followed anywhere. One, our proclamation takes how much? 60 days time.
Proclamation has been done.
So the trial in absentia can easily proceed. That's nobody is following. Nowhere. I have not seen any case where the court they are stopping the case. Again, when the accused is coming, they are reopening the case. This is also another factor which is contributing to the delay in all the trials. কি করবো এখানে সবাইকে দিয়ে দিচ্ছি এদেরকে দিয়ে দিতে হবে রিপোর্ট ইজ 3 so that portion is not very important is there are 3 elements over here 4 are there, one out of the purview. There are 3 elements. They are not quantifying, or they can only say that the falls under narcotics and is heroin. That would have sufficed the purpose. Now, once you say independently and each one of them are contraband, Supreme Court is partially correct for bail, maybe for conviction, something different. Learned advocate appearing aim for the petition 353 grams total subject matter. The learned advocate appearing for the petitioner, petitioners submit that petitioners are in custody for 10 months. And the recovery and the alleged recovery is 353 grams of heroin.
It is my renewal before just
Good stuff. Learned advocate for the state opposite is the prayer for bill as the quantum which has been as the contraband which has been seized is of commercial quantity. Records of the case reflect from the chemical examiner's report that there are 3 contrabands: diacetyl morphine, heroin দেবেন, তারপর 6 monoacetyl morphine and acetyl codeine, which are covered under the NDPS Act, but the report do not quantify the same. Having considered the judgment of the Honorable Supreme Court in sent to say A was the state of West Bengal, SLP number and the period of retention of the present petitioner. I am inclined to allow the prayer for bail of the petitioners. Petitioners shall furnish bond of rupees 20,000 or to surety 6,000 each, one of whom local. Satisfaction of learned judge, special court, 4th court under NDPS Act Malda. If on bail, petitioner shall be physically present on each and every day before the learned trial court and shall not leave the district of Malda without prior permission of the special court. Deeply obliged. Calm. To yesterday you was not there. Yesterday you were not there when the matter was called. Yes, Mr. Devashish Roy was there. Yes. Today also. চারটে ক্যান্সেলেশন আছে, ভ্যাকেশন জাজের কাছে নিয়ে বেরিয়ে গেছে। On the same footing you are wanting to.
That's why when I came before your lordship, my all asked.
You know? And chemical examiner's report depends submitted, we kept with the records. মিস হয়েছে মক্কেলে মামলা নিয়ম করা যায় নাই নাকি not today. Who is there? 28. She pays for time.
I'm for the statement.
Lord, petitioner before your lordship is a lady, my lord. 590 grams brown sugar from in the final report, my lord.
500.
598 grams, my lord. 3 NDPS substance, my lord. 1 neutral substance. Page, my lord. 30
From the
reports, my lord.
position.
Chemical examination report in the final report.
How many days?
40. As
Charge sheet submitted.
submitted, my lord.
Charge.
Charge not with my lord. Some of the
It fixed on 12th of May.
Process completed.
The bail prayer of the one of the accused, Oshim Sheikh, was rejected on 6th of April 2026. And there is a CDR, and the present petitioner and the Oshim Sheikh is,
Same footing.
there is a phone call between them.
That is only co-accused statement. You from you him recovery is made.
recovery is
Well,
made from 3
recovered from
person,
the
my lord.
possession.
From the Juhru Sheikh, Miss Baul, and this petitioner Tajbira Khatun, my lord.
Tajbira
And on the point, my lord, that FSL report.
on the possession of the present petitioner also, my lord.
That is when 6th of April anticipatory was rejected.
My lord, anticipatory.
Anticipatory and bail are two different things. Learning aid, advocate aid appearing in for the petitioner submit is the petitioner is in custody for 244 days and charge sheet has already been submitted. Copies have been supplied. Then how are you relying?
Certified copy, page 30, kindly think, my lord.
Page
30. Certified copy.
certified copy of chemical examiner's report.
No, my lord. This is certified copy of charge sheet. The reflection of report is, my lord, quoted here, my lord.
Page which page?
Not page 30 of my page.
30.
30. From the bottom, my lord. 4 lines above. That quotation is there.
Four lines on the bottom. Page 30.
Page 30, my lord.
Paragraph starts with actual.
Second para, my lord. Second para, 4 line from bottom. From that para, my lord. Second para.
Second para from the bottom or top?
Second para, my lord.
ये शो की है बोलम copy is have been supplied. Copies have not been supplied. Learned advocate refers to the charge sheet 8 at which charge sheet and submit 8 that it has been referred so far as the chemical examiner's report is concerned that the contraband contains diacetyl morphine, 6 monoacetyl morphine and morphine amongst the contraband along with 8 other substance. Full stop. Dilo to. You already given to memo of evidence.
My lord.
Huh?
My lord, I have read.
This is the second copy. It had to. Acha, the learned advocate for the state opposite is the prayer for bill and refers to the earlier order of another co-accused whose namely Oshim Sheikh, whose anticipatory bail has been rejected. So, acha, the Purpose of anticipatory bail and bail are distinct. Petitioner was throughout in custody in course of the investigation. So far as the chemical examiner's report is concerned, there has been no quantification in respect of the contraband. Having in regard to the judgment of the Supreme Court, Honorable Supreme Court in Sentusek State of West Bengal, SLP number ta diye deben. I am of the opinion that petitioner may be released on bail accordingly. Prayer for bail of the petitioner is allowed. Petitioner shall furnish bond of rupees 20,000 to issue 10,000 each, one of whom must be local, to the satisfaction of the learned judge, special court, come additional district judge, fourth court, Malda. If on bail, petitioner shall be physically present on each and every day before the learned trial court and shall not leave the district of Malda without prior permission of the special court. Accordingly, CRM NDPS 731/26 allowed. Memo of evidence submitted be kept in the record. এটা পেজ 30 তে আছে, মার্ক করে দিয়েছি এখানটা, হ্যাঁ টিক করা আছে, দেখবেন পেজ 30 তে ফ্ল্যাগ করে দেবো। Eight. হয়ে গেল। If the case diary or no, come tomorrow, come tomorrow. Not today, come tomorrow. So whatever. Huh? So who he is there? So, so let him come. Huh? Matter will be there. I'll consider it.
3190 bottles of fencidil from co-accused. I am in custody over 9 months. There are 3 accused persons, my lord. The earlier rejection order, my lord, on 16th of February 2026 by your lord. Alice is the order, my lord. Only co-accused statement and according to their CDR.
And one more NDPS case, that is Balughat PS case 459 of 20.
That is also co-accused.
They are into this business, and in this case, my lord, the earlier rejection reveals that there was continuous telephonic conversation during this transaction.
No supplementary, nothing has been filed.
How many bottles?
3,190 bottles
from co-accused.
from a car.
And he is what?
He is the father of the person who fled the spot.
কাকেও ধরে নিয়েছে?
The last rejection order shows telephonic conversation between Samir, from whom it was recovered, and this person.
One. How many conversations?
But there were several conversations. But the report was also submitted, my lord. The last rejection order, if your lordship sees.
Last rejection of Jasimuddin, nahi?
Yes. Just before the, in my brief, my lord, just before the back sheet. It's a rejection of 16th of February.
And one Nashim Rizvi.
Yesterday was fixed for supply of copies, my lord.
Having regard to the fact that he is there.
That's all. No.
So that time was granted for filing supplementary charge sheet, huh? কি হলো সিডিআর গুলো আনেনি রেকর্ডে এখনো?
On that point, my lord, I have taken instruction.
No, what is the order sheet said here? Nothing has happened. No supplementary file.
Order sheet is up to 7th of March 21/4.
Supply last.
No, last order 21/4. Last. সেটা আমাকে দেখতে হবে।
Not today, come tomorrow. কালকে করে দেবো কি আছে? If it doesn't improve anything,
Yesterday.
Better it will be, my lord, subject to your lordship's approval, my lord. Let me get a report.
What report? I have the order sheet, but I will find the order sheet.
so Friday, Matter is retained in the list. Call for a report. If it is not available tomorrow, day after, I'll take up these 2 days. Not today only.
Yeah, you will say you will always file and that will never happen.
The matter is retained in the list. No issue.
I'll come back.
Not today.
Friday.
Let's pray tomorrow. You have a resolution. I'll move back.
File charge sheet within 2 days, my lord. Had directed, yes,
Submitted. No new information.
my lord. I have spoken to the IO, my lord, because of the election. It will be done after election, my lord, because of election is busy in election duty.
কোন ইলেকশনে কি কাজ আছে একটা মুর্শিদাবাদ তো
Yes, my lord. Yesterday it was taken up. My lord had directed me to direct the IO to submit the charge
হ্যাঁ
sheet.
তো 20 কেজি 500 গ্রাম তো
He will submit it within next week, my lord, because of election only, my lord. He said it would be difficult to submit it within 2 days, my lord.
এটা কথা হলো এটা by this time
Lord, FSL is there, my lord.
so what is left to submit the charge sheet, sir? 5 months 16 days somebody is in custody. Submit
Within Monday, my lord.
এটা acha learned advocate aid for the state submits that efforts are being put in to conclude the investigation. Efforts are being exerted for আজ কত 22 29th I'm keeping the matter. Let the bill application be accordingly. Let the bill application be listed on 29th of April 2026 under the same.
29th, my lord. There is
29th এখানে না
30th, my lord.
30th.
Petitioner and another total 99 bottles of fencidil. I noticed my application in 19th January. Now I am in custody.
Charge sheet submitted.
Charge sheet submitted. More than 10 months in custody.
Learned advocate appearing for the petitioner submits that the subject matter of the case relate to alleged recovery of 99 bottles of fencidil, and the petitioner is in custody for 10 months. The investigation has already been concluded, and the prosecution intends to rely upon. Hi, কি হচ্ছে 99 24টা সাক্ষী 99টা বোতলে এই কেস কোনোদিনই হবে না কি বললাম and the prosecution intends 24 witnesses in order to prove its case. Learned advocate for the state opposite is the prayer for bail having regard to the period of detention, and the number of witnesses is proposed to be examined by the prosecution. I am of the view some time will be consumed in taking the trial to its logical conclusion. Accordingly, the petitioner be released on bail. This is not a foreigner. This one is not a foreigner.
Foreigner is Tahami Hussein is
ওই করে দিন ওই petitioner shall furnish bond 20,000 একটা local to satisfaction of the learned additional district 8 and sessions judge second court come judge special court under NDPS Act Behrampur Murshidabad. If on bail petitioner shall be physically present on each and every day before the learned trial court special court and shall not leave the district of Murshidabad without prior permission of the special court. Accordingly, CRM NDPS 741 of 2026 is allowed. কত এনডিপিএস আছে ও কাল রোজ করছি কমছে না তো 35
nothing has been recovered from the petitioner. From the house of Nobin Mondor, 45 kg of Ganja was recovered. Nashita Mondor, page 11 has been granted anticipatory bail by dishonorable court. Subject to correction, petitioner is on the same duty. I was arrested on 19th of February 2026.
This 19th.
19 February 26. 2 months, 11 days.
After charge sheet, you were arrested.
After charge sheet, I was arrested.
Warrant of arrest.
After supplementary charge sheet was arrested. Now, my lord, next date was 18th of May because one of the accused persons was absconding. Subsequently, she has been granted anticipation charges are not. And supplementary is the same shooting.
Same footing.
That's what you said.
No serial money trail, nothing. Learned advocate appearing for the petitioner submits that the subject matter of recovery in the present case is 45 kgs of Ganja. However, there has been no recovery from the present petitioner, and he has been arrested on the basis of statement of co-accused. Learned advocate for the state opposite is for bail records reflect that how many witnesses in total?
16 witnesses.
Supplementary and charge sheet. Learned advocate records of the case reflect that there are 60 in charge sheeted witnesses. Comma. Now, records of the case reflect a petitioner has been arrested on the basis of statement of co-accused. And there are 16 witnesses on whom prosecution proposes to rely in order to prove its case. Full stop. As time as some time is required will be consumed in taking the trial to its logical conclusion, and there has been no specific recovery from the present petitioner. I am inclined to release the petitioner on bail. Petitioner shall furnish bond of rupees 20,000 with surety is of 10,000 each, one of whom must be local to the satisfaction of the learned additional district session judge. Second court come special court NDPS Act, Berapur, Murshidabad. If on bail, petitioner shall be physically present on each and every day 8 before the learned 8 trial court and shall not leave the district of Murshidabad without prior permission of the trial court. Thus, CRA aim NDPS 742 2026 is allowed.
Okay, six.
Yes. Yes, sir.
30.45 of Ganja, I am in custody for 300 days. Kindly come to it's 9 and 10 of my activity. 9 and 10.
Yes, sir.
Order dated 21st January.
So seizure list witnesses examined.
No, but kindly out of 14, 2 let me submit.
I submit.
Consider one thing, when the matter was rejected earlier, it was directed by this honorable court that the seizure list witness will be given priority and that will have to be completed within 31st March. 31st March is over.
So when did you communicate the order?
Order was communicated.
Where? Which order sheet? Show me.
But thereafter, 2 witnesses have been examined. That is 2 police witnesses. Kindly come to.
Those are what? Seizure list witnesses.
Kindly come to page 15 to 18 and 19 to 20 first.
I will come to that. First, show me the page where have you informed the order to the trial court, number 1. And who are these witnesses?
These 2 witnesses are the charged. Those who have been examined, they are police. They didn't give priority to the independent witnesses.
So then show me how have you communicated the order. You must communicate the order. I will pass order that will be known to the trial court that is not the system. Some communication must be there. If I have to hold that the trial court is wrong, then I must be confirmed regarding the fact that in spite of.
Can you come to the impugned order?
Which is the impugned order? Bail.
The last 2 that's not present.
Certificate copy.
In certified copy. Reduce the order dated passed by the Honorable Court of Calcutta. High Court is not rejected. In CRM NDPS 125 of 2026 dated 21st January 2026. That was communicated, otherwise it was not recorded. Wherein the Honorable Court directed the court to consider bail clear of the accused person in the light of the evidence adduced by the seizure witnesses. It was communicated, otherwise it was not recorded by this learned court.
So PW1 and PW2 are seizure list witnesses.
No. Videographer? No. They disobeyed the order of this honorable court. Seizure list witnesses was to be completed within 31st.
Who are the seizure list witnesses?
Charge sheeted witnesses number 7 and 8.
Raju Vishwas and Surojit Bari.
Signature of resolution is not there in the serial. It's only on witnesses. Signature is there. Kindly comes to the computer.
Well, two things I will just indicate your lordship. This is not a case of an only NDPS Act. 30 kg, 48 grams of Ganja along with 3 improvised firearms has been recovered from the possession of 3 persons. 6 persons, but as all these firearms are in working condition, interrupts in this passion manner, it's very tough to argue before your lordship. This is not correct. We have the sanction order. All the firearms are in working conditions. There are every signatures I will find. He said that there is no signature of.
How many seizure lists you have?
One of seizure list witnesses.
How many seizures?
One. I have marked the portion of the person, Surojit. The car also belongs to the present petitioner as well. Code of the RTO is at page 136.
In Namki accused.
Order was placed before the Learned Sessions Court on 17th of March 2026 on the very date of the rejections of the application, not prior to that.
Thereafter, 2 witnesses have been examined.
The charge was framed on 18th of January 2026.
অভিরূপ আর একটা কি আছে রাজেশ সিংহ So Rajesh is already a witness.
Well, he's not serial list witness.
He's a seizure list witness. Have you got a seizure list copy?
Well,
Huh? To see the last witness?
Surojit Bari. Last witness is Surojit Bari. Can you see?
কোথায় কিউই দিচ্ছে বলো তো দেখি
Rajesh Singh and Abhirup Mitro, they are the 2 police officials who conducted the raid. Charge sheet number 7 and 8, Raju Vishwas and Surojit Bari. They are the 2 independent seizure list.
That was developed by the trial.
when have you informed your prior to 17th you must give it order was passed when
21st of January 2026. 17th of March is the date of rejection. On that very date, the order has been placed.
I have said seizure list witnesses have been examined.
Indicated that.
Seizure list witnesses, they
Not in prioritized manner.
You are thinking independent. There are other witnesses over there in the seizure list.
They are police witnesses.
The police witnesses, so what? You see the witness list.
Are there? Other witnesses are there.
If you want to examine independent, then you have got to say, I want to examine. Have you over here? The order says come to page 10.
Having considered the witness যদি hostile হয় বা থানাতে সই করে তখনই বেলটা দিয়ে
It is written, however, the learned trial court is directed to give priority to the seizure list witnesses. So there are 7 seizure list witnesses.
But they have not done.
So that will take some time.
My lord had fixed time limit, 31st March, that will be over.
In the meantime, after that.
Kindly consider.
Yes.
Let the appropriate action be gone.
That I have seen.
31st March.
31st March. When have you? That is why I am saying the order was passed when.
Order was passed 21st January.
So when have you first produced the order? That is what I am.
No, before that. How?
So show me the order. You are showing the order of.
Thereafter, 2 witnesses have been examined.
No. This.
PW1, PW2. But kindly come to page 18.
You see the order sheets of that deposition are of which date? 10th of February.
And 7th of February.
So that is after 17th of March or prior to 17th of March?
After 17th of March. After the High Court order. Sorry, after the High Court order.
After the High Court order or when the order was placed, they have examined the complainant. For example, one is the complainant, the other is a witness as to the seizure. Huh? So
I have to take the information on what is order was written. I have to take from the court below. Make it notice.
what information? I'm just give priority to the independent witnesses. I'm specifying these two witnesses.
Or not these three witnesses on 4th, 5th, and 6th of May.
ঠিক আছে
They have examined two
We-
witnesses after the order of this Honorable High Court.
এটাই মুশকিল হয়ে যাচ্ছে চলে আসো। আচ্ছা in the earlier order while disposing of the bail application, this court directed aid for examination of the seizure list witnesses. Such order was passed on 21st of January 2026. There is nothing on record or that prior to 17/3/2026 such order was placed before the learned aid special court. One of the with the complete the one these are complainant, I believe, no Obhirup Moitro. One of the witness happens to be the complainant, the other happens to be a,
The other one is the videographer.
but he is a seizure list witness also. With the informant, and the other happens to be a witness to the seizure. Full stop. Petitioner is in custody for
Custody for 350.
For about for more than 10 months. It has been informed on behalf of the state that the next date has been fixed on
2nd of May, 4th of May, and 6th of May. 2nd, 5th, and 6th of May.
on and from 2nd of May 2026. The learned aid court, the learned special court is directed that wait, I've heard you enough.
And name of Rajesh Roy is not there in this cell. Sorry, kindly see, Mala. He's saying that.
Fare, you see the seizure list. I am seeing, I'm not hearing to him. I'm seeing the document from here.
That is right.
হয়ে আসবে না কিছু আসবে না কি বললাম আচ্ছা the special if it is not possible for the special court to complete the evidence of Surajit Bonik and Raja Bishas, two witnesses who have been cited amongst others in the seizure list. Learned trial court would within a period of 45 days from the said schedule complete the evidence of these two witnesses. With the aforesaid observations, at this stage the prayer for bail of the petitioner is rejected. Petitioner will renew his prayer for bail after the evidence of the said two witnesses is over. Rest I believe are the police witnesses, na? They are seizure list witnesses. One is a sub-inspector, one is a constable, one is also sub-inspector, another constable. 6 and 7, I will specify this time.
That charge sheet witness number 7 and 8.
আচ্ছা হয়ে গেল with the aforesaid observation CRM NDPS 744 of 26. Not fault of the trial court. In the meantime, all administrative works. Don't say this. Under what condition they were working, we know. CRM NDPS is 744/26 is disposed of. Yes.
Was recovered from one remote post. My name transferred from there below. I was not initially appointed nationally below. I was introduced on the 2nd of February. 5 years of below. After that, I was taken to an abandoned house at 1 o'clock in the night, naturally of independent witnesses, and 12 bottles of fencidil recovered.
How many days?
79 days.
Charge sheet submitted. Charge sheet submitted. How many witnesses in the charge sheet? 15.
Already
কত granted bail, statement of court, all total 26 bottles. আরে ওরম ভাবে হয় নাকি কেস?
Total 26.
চলে আসুন learned advocate appearing for the petitioner submit is the subject matter of the case involves alleged recovery of 26 bottles of fencidil. Full stop. Petitioner was subsequently arrested and out of the aforesaid 12 bottles have been recovered from the present petitioner. Full stop. Petitioner is in custody for 79 days, charge sheet has already been submitted and the petitioner as such may be released on bail on any stringent condition. Learned advocate for the state opposes the prayer for bail. I have taken into account the materials appearing in the case diary and the prosecution has relied upon 15 witnesses in order to prove its case, having considered the quantity of contraband and seized the time which will be consumed for taking the trial to its conclusion. I am inclined to release the petitioner on bail. As such, the prayer for bail of the petitioner is allowed. Petitioner shall furnish bond of rupees 20,000 with two sureties of rupees 10,000 each, one of whom must be local, to the satisfaction of the learned judge special court NDPS Act, come additional section third court Malda. If on bail, petitioner shall be physically present on each and every date before the learned trial court and shall not leave the district of Malda without prior permission of the special recordings. Accordingly, CRM NDPS 746/26 allowed. Yes. What is it? How many witnesses examined? চারটে আছে learned advocate appearing for the petitioner submits that the petitioner petitioner submit it's that petitioner is in custody for 2 years 5 months and only charges have been framed till date prosecution has relied upon 11 witnesses in order to prove its case. Further, it has been pointed out that the chemical examiner's report incorporate several contrabands which have not been quantified. Learned advocate for the state opposite is the prayer for bill as the quantum of recovery is 376 grams of heroin, brown sugar. Full stop. I have taken into account the period of detention of the present petitioner as well as the fact that in the chemical examiner's report there has been the results reflect that there has been results reflects presence of 6 monoacetyl morphine, acetyl codeine, morphine, 3 hydroxy 2 naphthyl ortho anisylide and NN diacetyl dianicidine. না না এটা দরকার নেই, লাস্ট দুটো দরকার নেই, তিনটে দিয়ে দিন, ওই 3 হাইড্রক্সি থেকে বাদ দিয়ে দিন, বাকি তিনটে আছে তো 6 monoacetyl morphine, acetyl codeine আর morphine. Having considered that the quanta so seized is 376 gram and the results reflect 3 contraband and without being quantified, I am inclined to and relying upon the judgment of the Honorable Supreme Court in Sent to say A versus A State of West Bengal, SLP number 30, I am inclined to release the petitioner on bail. Accordingly, prayer for bail of the petitioner is allowed. Petitioner shall furnish bond of rupee is 20,000 with two surety is of 10,000 and each, one of whom must be local to the satisfaction of the learned Malda learned special court under NDPS Act Malda. If on bail the petitioner shall be physically present ওই দুটো দিয়ে দেবেন, হ্যাঁ, and shall not leave the district of Malda without prior permission of the special court. ওই accordingly CRM NDPS number 747 of 2026 is allowed.
On your 2 months.
Charge sheet submitted. 1 year, 2 months. Yeah, how many? Two contrabands. So I should 6 monocetyl 250. The same is there. Huh? The same contrabands are there, na? Chalo. Learned advocate appearing for the where is the seizure list? Two seizure list, naki. So one is 103 grams and another separate packets, naki. 103, 103, 104. কি বললাম? এই একই প্যাকেটে ভাগ করে diacetyl morphine and 6 monoacetyl morphine in both the in 3 packets same কি বললাম submit that the petitioner is in custody for 1 year or 2 months and the alleged recovery is 310 grams of heroin brown sugar the heroin লিখছে এখানে টেস্ট 310 grams of brown sugar from the possession of the petitioner and others. Now, from the petitioner. Charge sheet has already been submitted as such. Learned advocate 8 submits further retention is unwarranted. Learned advocate for the state opposite is prayer for bail. Records of the case reflect that the contraband and untested reflected two individual compounds diacetyl morphine and 6 monoacetyl morphine having considered the quantum of seizure and that no quantification has been done relying upon on the judgment of Sentusek versus State of West Bengal. SLP number 10, I am inclined to release the petitioner on bail. Petitioner shall furnish bond of rupees 20,000, two surety of 10,000 each, one of whom must be local to the satisfaction of the Malda Naki. Learned Judge Special Court additional district judge, 4th court Malda, if on bail, petitioner shall be physically present on each and every date before the learned trial court and shall not leave the district of Malda without prior permission of the special court. Accordingly, CRM NDPS 748 of 26 is allowed. Chalo.
Number 40.
Who is? Yes. Not today, tomorrow.
Investigating officer.
So come tomorrow.
Sorry, tomorrow it's not possible.
Which district?
Usefully.
Tomorrow. Election tomorrow. Huh?
Election how possible for him. I have already because there are various questions that I have to.
So when?
Day after 4th.
This is the way.
Otherwise,
detention is illegal. That's why this lady accused person without having any lady officer, without having any magistrate's warrant, I have been accused.
So ask.
Send it to your lordship, my lord, without going through the case there, it's very difficult to
So you go through the case diary.
Of course, ma'am.
So if the election is not there, ask him to come tomorrow. If it is there, then ask him to come subsequently. As simple, but we can't wait till 4th of May. Tell me to.
Better, Shukrobar.
Then fix it on Monday.
Monday will be difficult for him if the election is on 29. Then if I am fixing, I will not grant it.
What the 123rd?
No, it's on 29. That is why he's asking for. I can understand, ma'am.
If on 22nd for 29, 1 week ago, you say you can't come to court. And it's your requirement, not even the court's requirement.
My lord, may I, my lord, with the deepest of respect, my lord, there are possibly some other, my lord, corners, my lord, which we really need to check, my lord. I understand it's our requirement. I understand, my lord. But, my lord, he is in some difficulty. My lord, there are certain...
Friday, instead of tomorrow, ask him to come on Friday. So you want from 4th of May, is it possible? You tell me.
If it's possible, my lord, it's not for me to stand in the way. Your lordship, my lord, is aware of that.
Lord, no, that is a deal. I will not enter into the zone of May now. Let's concentrate on April only. Huh? So then the court have to be closed, sir. What is the use?
My lord, I wouldn't.
We are fighting with the lawyers to do matters. Then if the administration is also not cooperating, requirement, either he sends a clarification, you know what he has done. After going through the case diary.
Some of it, my lord,
NDPS cases, there is no tough situation, sir. You know what he has done. You want a shield for yourself.
No, not, my lord, in this case, not mandatorily, my lord. Kindly, my lord. My lord, it wouldn't have been, my lord, fallen in that way, my lord. Your lordship kindly considers only, my lord, this as, my lord.
To when? I am considering only. I am not hearing the matter.
29th again, my lord, will be a difficulty, my lord.
29th
again, he has, my lord, made an earnest request that he, my lord, cannot present himself.
So Monday, but Monday he has got to come then. See, that's your part of the case. He has got his part of the case.
My lord, takes it up on Friday then. My lord, we will try our level best.
Ask him to come on Friday. Not today. I'm not passing any order. But pressurize you. Everyone wants to go away from the court.
So the situation has become such, my lord, to pressurize, my lord. We are getting pressurized later on. That's the situation, my lord. Because, my lord, people are saying, I'm going to do this, I'm going to do that. And, my lord, once in a while, we don't have answers.
So, at least ask him to send some written clarification. We can proceed. May not be, we'll dispose of the matter. But nothing will be done before a court of law. How can we? Ask him to send some written instructions on mail. We'll keep that on record. We'll proceed with further clarification. But
my lord.
Nothing will be done in court of law. That is also an embarrassing situation.
My lord, I appreciate it. My lord, my lord, your lordship keeps it on Friday, my lord. To the best of our efforts, my lord, whatever is available, we'll present it before your lordship, and my lord, your lordship will take it.
Not today for the timing.
I am ready.
42.
For the petitioner. Petitioner is in custody for 2 years.
Wait.
State case, right?
No, we don't have the case diary today.
Not today, chalo.
ये तो मतलब तो वोटर आ गया मतलब 23 तारीख को सामने
The file yesterday or what?
Not.
Chalo.
44.
I'm for the state.
But this is the seizure list. 460 grams of brown powder suspected to be brown sugar has been recovered from the vanity bag of one Sophia Bibi. But nothing has been recovered from the possession of the petitioner. I am in custody for 10 months. And 3 derivatives, 3 variances in the chemical report. That is also there.
460. 460.
460.
Statement of co-accused.
Yes.
Lordship, there is last thing.
Let me complete. Statement of co-accused. Arrested on?
Arrested on 1st July 2025. First, a lady was arrested, and thereafter,
Same day.
She said that she is going to deliver this thing to me, and thereafter
one place I was standing in, I was sitting in my car. After 3-4 hours, my lord, I have been arrested. Now, my lord,
কালকে হয়েছিল গতকাল
yes, yes, it is that case, my lord. And your lordship, yesterday's submission was that the charge has not been framed. And my lord, a discharge petition has been filed. On that score only, your lordship rejected. And my lord, my submission, your lordship kindly sees the last order. Charge has been framed in reality on 9/4. That is clear order passed.
এরকম অ্যাডভোকেট ছেলে মেয়ে হবে
My lordship, there is a video footage where all these three people were seen together. And there is CDR, there is criminal antecedent.
হ্যাঁ তো but then you
But
are
if
not
there is an order also that
I'm not on that. I'm not. Why are you not complying with the Supreme Court's direction? Why are you not quantifying the contraband? There are three কোথায় আছে chemical examination
That flag mark, flag mark.
তাও হচ্ছে না two elements are there, morphine and thebaine is there. So 250, 250, what is the commercial quantity of thebaine? 50.
Anyway, my lord, nothing has been recovered from my possession. Lordship kindly sees the
there's no
CCTV.
recovery from him, there's recovery from the lady.
Lady.
But you say she says that from the CCTV footage,
Yes,
all of
he
them
was
were
there.
found.
Both
Not in the
three,
spot. Not in the spot.
slightly away from the spot.
দেখো না thebaine টা কত
Lady
I'll show you the
lady
statement.
My lord, I was the ex-Panchayat Pradhan. Earlier, on same fashion, I have been roped in another case. I have been acquitted. Similar fashion, my lord. This is the acquittal order.
দেখি ওটা দেখি see the commercial quantity of thebaine
200 grams. কত? 200 grams.
200 আর এটা কত অন্যটা মরফিন 250
Morphine is 250. নেই মামলায় ওনার সাথে কথা বলে লাভ নেই
this is an apprehension তো গাড়ির দিকে যাচ্ছিলেন তো
CCTV
গাড়ির দিকে যাচ্ছিলেন
গাড়ির দিকে যাচ্ছে।
দিকে যাচ্ছিলেন তো
But the car is also seized. There's another, no, not a different car. The seizure list is also
I
there.
have seized that. I have got no issues regarding this. I'm considering a bail application,
তার সঙ্গে কি সম্পর্ক
not considering a conviction তো হ্যাঁ except this, what do you have? She was not within the car. She
She
was
was not within the car. She had come all the way from Manipur over here. And then the other person, Masidul, had come to receive her.
this person is from where?
The lady
This person, petitioner.
from Malda.
Malda?
Okay. He was earlier acquitted when he,
similar person
This instruction is not with me because today morning only I have received the case diary and the IO couldn't apprise me regarding the acquittal or the conviction.
this order.
I brought it. That is why I brought it. And see this nature of allegation, my lord, nothing against this petition.
Not found. Learned advocate for the petitioner submits that the petitioner was acquitted in connection with special case number 41 of 2017, which was also under section 21C and 22 of the NDPS Act, wherein petitioner was similarly implicated as an accused. Full stop. In the present case, petitioner has been arrested, and the accusation against him was that he was sitting in a car towards which the accused from whom recovery has been made was proceeding. Full stop. To the at FA, there has been the prosecution. No, eight line take to that effect. It has further been submitted that the petitioner is in custody since 1st of July 2025, and since then he is in custody. Charges have already been framed by the learned trial court. Full stop. Learned advocate 8 for the state opposite is a prayer for bail on the ground that commercial quantity of contraband has been seized. Although the seizure was from a different accused person, but the petitioner was waiting to receive the contraband.
And in the vehicle is also in his name.
Vehicle, no recovery from the vehicle too.
No recovery.
Acha, learned advocate 8 for the records of the case reflect that the recovery in the present the chemical examiner's report relate to chemical examiner's report reflect availability of two contrabands, morphine and thebine. The commercial quantity of the first being of 250 grams and the other being of about of 200 grams. Full stop. Petitioner having regard to the quantum of seizure, period of detention, and the fact that petitioner has been arrested in the present case pursuant to his acquittal in a case under NDPS Act earlier instituted in the year 2017, and the said acquittal was on 14/11/2024. I am of the opinion that petitioner is entitled to some benefit. Accordingly, prayer for bail of the petitioner is allowed. Petitioner shall furnish bond of rupees 20,000, 10,000 each, one of whom must be local to the satisfaction of the learned judge. Special court, third court, Malda. Also, if on bail, petitioner shall be physically present on each and every day before the learned trial court and shall not leave the district of Malda without prior permission of the special court.
Now should let a memo of copy be kept in the records.
You are fresh, this is underlined too. We thus CRM NDPS number 754 of 2026 is allowed. Memo of evidence submitted aid by the state. It into fair din a fresh dilo. Memo of evidence. A memo of evidence and submitted by the state be kept with the record. The judgment relied upon by the learned advocate for the petitioner be also kept with the record. So, এটা কার কতগুলো সিডি পড়ে আছে এখানে?
This is mine, Lord. This is my copy. আমার copy.
ওইটা ওনার কপি আর এটা সিডি। নেক্সট। পরেরটা রাখো 40। What is the recovery? How many days?
69 days that
269 days. Charge frame.
Can you see page 12?
Yes, yes.
Procedural order.
Huh.
In respect of this petition. Petition legal is 185 days. Petition কোনটা ভুল হয়েছে?
Where is the subsequent order?
My lord, subsequent order means, my lord, of this court.
Who has been granted bail? He's saying one person.
Before that, before. And kindly see the order of the order by, okay, I am telling your lordship. Subsequent order is 2/4/2026, page, yes, page 1, page 7. Page 7, next P1. It is on 2nd of April, subsequent, yes.
Is 2nd of April.
Page 7, man.
Hey.
Out of 40, only 156. Nothing was recovered.
They were in custody for 15 months. So.
Nothing was recovered from high position. The person from
Case was initiated on 16/12/2024. He remained absconding and thereafter, my lord, he came to surrender on 28/7/2025. That means, my lord, almost a period of 7 or 8 months he remained absconding. Thereafter, he surrendered.
Surrendered. Charge framed when?
only 1 week is this.
After February, nothing has been done in the trial court, sir.
Charge frame to the month of September 2028. September 2028.
Where is it? That witness did not support the case. Did not support the case.
I don't have a copy of the deposition, but yes, my lord, he did not support the case. You are noting of the earlier.
Dictate. The statement of co-accused, basically. Oh, CDR.
Constant called among the 3 persons from whom seized as this petition.
Why are you coming without completing, sir? Why are you coming in? There is a direction of the court. Why are you coming in prior to that?
As because the person from just recovered.
So he is on 15 months custody. So that is your consideration. এই তো মুশকিল হয়ে যাচ্ছে তাহলে সবাইকে বন্ধ করে দিতে হবে if you come like
Article 21 on the premise of Article 21, those 2 persons have been granted bail. So far, this person is concerned, my lord, he remained absconding for a period of almost 8 months. And then
signed after anticipatory rejection.
He applies the court.
No. There is a direction. I will not deviate from that. Come after the way. Learned advocate for the petitioner do not intend to proceed with the bail application. Learned advocate for the state is present. Accordingly, CRM NDPS 756 of 26 is dismissed as not present.
It's not up to us. And it's not up to us. Shall come down to the house. 47.
Come tomorrow.
48 my time for the statement.
Yes.
From 3%. Taken back of taking was there.
How many days?
Custody for 8 months, 10 days. Correction.
Charge sheet.
Charge sheet submitted against 4%. Another activity that's on the
But page 129 is the chemical examiner's report.
তো আছে তো 267 267 seizure. Learned advocate appearing aim for the petitioner submit aids that petitioner is in custody for 8 months. Charge sheet has already been submitted and how many? And the prosecution has relied upon 19 witnesses in order to prove its case. Learned advocate aid for the state opposite is the prayer for bail 267 grams বললাম opposite এটাই বল লিখে নাও জানা লিখে নাও opposite the prayer for bail and submits that 267 grams of brown sugar has been recovered. And the same is of commercial quantity, full stop. I've taken into account the case diary, and from the chemical examiner's report, it reflects that there are presence of 2 contraband, 6 monoacetyl morphine and diacetyl morphine. Full stop. No quantification has been specified in the report. Having considered the same and relying upon the judgment of Sentuse A State of West Bengal, SLP number the I'm inclined to release a petitioner on bail. As such, prayer for bail of the petitioner is allowed. Petitioner shall furnish bond of rupees 20,000 with 2 sureties of rupees 10,000 each, one of whom must be local to the satisfaction of the learned additional district and session judge. Second court come judge, special court NDPS Act, Berhampur, Murshidabad. If on bail, petitioner shall be physically present on each and every day to the learned trial court and shall not leave the district of Murshidabad without prior permission of the special court. Thus, CRM NDPS 758 of 2026 is allowed. Sure.
Grateful, man.
ये पार्ट दी ये আছে কি হলো নট টুডে করে তো কি করা যাবে রেজলিউশন নিয়ে বসে আছে
first order, the last order passed by your lordship. Next order is a case 16 and 17 of the application. What the relevant court
16-17 কি আছে
the direction order passed by your lordship, correct? But your lordship was passed a specific direction.
The prosecution would examine the seizure list witnesses on priority basis, preferably within a period of 45 days from the date of consideration of charge. That is most probably his purpose.
Yes, now I come to the very next.
Yeah.
Can you the order date 14th of January 2015? When this order has been communicated, 11th. Now, in the first place, it was this dated 22nd of January 2026. On 22nd of January 2026, the charge has been framed. Violating the directions passed by the Honorable Court, the date for examination of the seizure list witnesses has been fixed on 28th of April 2026.
So what they can do?
But there are the direction from this Honorable Court to consider the consideration of the evidence of the seizure witnesses by 45 days from the date of filing of the charge.
That is a tentative direction. Even if the date was fixed by that time, what would happen?
All is active. That
Yeah.
is why that is not. All is active. Court was closed.
On the 22nd of January, there was no FIR duty. There cannot be any FIR duty. Secondly, when Dr. Kali considers the alleged recovery is of 301 grams. The two charged to single witnesses whom they are projecting, they are from Goya, different state altogether. Whom they are projected to be a local single witness.
ঠিক আছে কি আছে কেমিক্যাল এক্সামিনার ঠিক আছে তুই তাহলে অ্যাডভান্টেজ পাচ্ছে তো কতদিন হয়েছে
1 year, 2 months.
1 year, 2 months.
চলে চলে এসো learned advocate appearing for the petitioner submits that earlier the prayer for bail of the petitioner 1 or 2 earlier the prayer for bail of the petitioners were rejected. It has been pointed out that the alleged recovery in the instant case is of 301 grams of heroin. Petitioners are in custody for 1 year 2 months. And till date, only charges have been framed and witness action has not commenced. Last date, no witness action. 22
April is the date.
28, and the witness action has not commenced. Gallo. Learned advocate for the state opposite is the prayer for bail. Records of the case reflect that the chemical examiner's report wherein 2 contrabands have been detected, diacetyl morphine and 6 monoacetyl morphine. Full stop. There has been no quantification of the same as per the report or thereafter by the investigating agency. Consequently, the judgment of the Honorable Supreme Court in Sentusek versus State of West Bengal in SLP number A is applicable. Petitioners as such are released on bail. Petitioners shall furnish bond of rupees 20,000 with 2 sureties of rupees 10,000 each, one of whom must be local to the satisfaction of the learned judge, special court under NDPS Act, come additional session, 3rd court, Malda. If on bail, the petitioner shall be physically present on each and every date for the learned trial court and shall not leave the district of Malda without prior permission of special court. Accordingly, CRM NDPS 761 of 2026. এভাবে হতে পারে না ইস্যু দেবো অর্ডার শিট থেকে Madam will be there in the list. Why? Regularly, yesterday I have called, today I am calling. কালকেই ডাকবো আবার You are staying in Calcutta. What you have got to? কালকে টিভি চ্যানেলে নাকি টিভি চ্যানেলস No, tomorrow is a whole day. No, once I have seen you in the afternoon hours also. No, in the afternoon hours I have seen also in this type of dates. Recollect? Not today. আরে you have taken a resolution. মানডে কি হবে আমি বলতে পারবো আমি রোজ ডেকে যাবো এখন আসবে 2 জন থাকলে করে দেবো গেল Not today. Not this week I can't give. Not today, let it be. If tomorrow, pray for accommodation regularly. No CD. Next. Tomorrow. No CD.
Yes. 68 kg of Ganja.
আরে আগে আসুক কি রে এবার অপোজ করলে আমি তো পুরো মামলায় ঢুকে যাবো তো which item 57
When I am for the petitioner in this matter, my lord.
is no case diary tomorrow
Grateful.
কালিয়াচক এখন হবেই না কালিয়াচক এখন দেওয়া যাবে গেল 59 ঠিক আছে, তারপর কি আছে? দেখে যান, এই আরম্ভ হলো।
Not today. I got it. 45 or
At the not today, this is also not today.
not this weekend.
No, no, she prayed. I granted not today. Yes. And state is not there too.
The victims
Petitioner is directed to hand over a copy of the bail application to the learned advocate appearing for the state. Learned advocate for the state would, through the officer in charge of the concerned police station, effect survey is upon the private opposite aid party. You are 63. 63 তে হয়ে গেছে, হ্যাঁ, ওই enclosing the acknowledgement করে দেবেন, হ্যাঁ, submit a report before this court enclosing the acknowledgement of the private party. Let the matter retain its position in the list.
But I will state there was a direction for service, reservice actually. No, there is no report to that effect.
This will run like this. আবার কোথায় সরাবো এখন?
65,
Yes.
66.
Where is Mr. Devashish Joy? He said that he'll be appearing in all the matters. Huh? কোথায় গেল? কে দাঁড়াচ্ছে না কেন? You have taken a resolution. I cannot pressurize. হ্যাঁ, নিয়েই নিতাম আমি।
66.
Not today.
68.
No adjournment from state.
দেখে যান, দেখে যান।
70. 1.
দাও দেখি কি আছে। 70, nobody was there for the petitioner. 70.
71 আছে।
70, sorry, 74. Sorry, it's my mistake.
71, who is appearing?
71.
দেখে করা যাবে। 70.
73. 74.
Ready? 72 টা দাও তো লিস্টে। 72 টা ভোটার। How many accused persons? So that the injuries were found on the body of the person. In the postmortem report, it's apart from drowning, there were injuries. So yes, I postmortem report. There are injuries on the body of the person. What is a motive?
Kindly see, my lord, the statement, my lord, the page 159, 160. That is the doctor's statement, and my lord, two statement. Father of the victim 178, 179 mother, and my lord, the local people 182.
What is the motive actually?
Prior to the incident, they were together.
No, that is last scene. And motive
They are
circumstantial evidence এর কেস তো আমি ডিউটি থাকাকালীন চিফ জাজের ডেড বডি নিয়ে আসি ওয়ান
182. 182 is the local neighbor of the victim, and father and mother is 178.
Just 1 minute, 1 minute. আমি চিনি আমাদের পাড়ার ছেলে কিন্তু
Teaser list, kindly have a look, my lord. Page 44 and 45. Deceased one pair white sandal and one jeans full pant of the deceased. 44, 45, and my lord, statement of the reading statements, that is my lord, 49. And charge is submitted against this petitioner.
Oh, that I understand, but this is the standard of the evidence you see. Have you seen these pages?
That pages I have seen, my lord.
You হয় নাকি কি করে করব?
And my lord, he is in custody about 8 months, but or kindly have a look, my lord, the order dated 7/1/2006, lower court order 26. The further investigation is on progress.
That is why I am asking you, what is this spur of the moment, provocation, previous enmity, what is there?
There was a relationship like that, but because prior to the, kindly see the
which page?
Page 178 and 179. Father and mother of the victim.
Of the disease?
Yes, my lord. Victim.
আমার ছেলে আসছে সকলে মিলে গুজরাটে আনে না আমি কাছে আমাদের কাজ করি হ্যাঁ তারপর সারাদিন তারা কোথায় ছিল বাড়িতে But point of enmity or anything previous, nothing is coming out.
That I have seen.
Huh?
The FIR said stated that person come to the house of the de facto complainant to inform the incident.
FIR can be a cryptic set of facts. Now full investigation is over.
Now further investigation is on progress. As per my, kindly have a look. The page.
No, that is all right. But this is amongst the relations only. All are related.
No relation.
As a সম্বন্ধিত মামুন সরকার মামাতো
Mama.
Accused is মামাতো Ashik
she is a civic volunteer. She was along with Mamun.
Ashik Sarkar
আশিস সরকার is a victim, my lord. Victim.
স্বামী স্ত্রী এবং দিস ইজ আয়ুব মন্ডল স্টেটমেন্ট ও আচ্ছা মামুন সরকার
Mamun Sarkar is the petitioner before your lord.
মানে why are they apprehending Mamun as killed him? Everybody
Because last day of the incident, my lord, she was with the victim was with the my lord, with her, along with one civic volunteer, my lord.
সেটা লাস্ট সিন তো করতাম ওই পর্যন্ত ঠিক আছে তারপরে কিছু একটা অ্যাড করতে হবে
That my lord, one diseased white chop sandal and my lord, the one jeans pant was that is 44 and 45 season list kindly see.
covered from
See cover that has to look into my lord. It's 44 and 45.
something else statement
43 and mobile phone 50. Sorry, 43, 39 and 50 is mobile.
43 তে কি আছে
কি দিল দিদি নাম ও কোথায় তো ভোট দিতে কি না যা যা আছে সিজন লিস্টে
date of the incident
Date of the incident, my lord, is 13/8/2025.
17 তারিখে one pair white color
Both are of same age, my lord. Petitioner 24 years, victim was also my lord 24 years.
cases from where
Cases of my lord Topon PS, Dakshin Dinajpur.
You
and my lord, kindly have a look.
No, no, it's all like you call the IO, assess what is the circumstance. Up to last scene, charge sheet submission, it is all right. You did an
Submission, but kindly have a look, my lord, page 123 of CD, my lord. That order dated 21st second to the further investigation is on.
No, further I am accepting that. But the fact remains is that something more is required to detain a person. 8 months somebody is in custody, initial charge sheet submitted. Some X factor over here. There was a previous enmity, somebody was there, property dispute. Something some more thing.
Motive is lacking, man.
Cases I have to come.
Then, my lord, tomorrow is election there.
This is far.
Topon is far over.
এখন হবে না এই 4-5টা ডিস্ট্রিক্ট বলে দিতে পারি পেপারে দিয়ে দিতে বাট সামথিং ইমপ্রুভ সামথিং otherwise it is very difficult everybody apprehend.
I will ask I want to come with a report in respect of the further investigation.
Point of dispute, sir. I am wanting that. See, you have already got a thick city. But each and every witness is suspecting him. As he was last
because it is a case of last scene and it is a no eyewitness is there, but entirely circumstantial evidence.
So, circumstantial evidence, some motive is required.
Motive has to be.
I have considered the case diary produced by the learned advocate. The issue of motive. In the cases of circumstantial evidence, the statement which shall be read, which shall be produced from the case diary reflects that most of the witnesses apprehend that at the present suspects that the present petitioner
Original case diary was to produce.
I am wanting the motive only. Suspects that the present petitioner committed the alleged offence. However, there are no materials to suggest is that, however, at least the court could not be apprised relating to motive A which could have led the present petitioner are to commit the alleged offence. Gallo. It has also been pointed out by the thing that further investigation, the investigating officer either he will be physically present or would forward materials collected in course of the earlier investigation or the present investigation relating to the complexity of the issue relating to the learning activity appearing in the state. The bail application be listed in the monthly list of May, 5th of May to come.
5th of May.
5th of May, 2023.
But instead of 5th, it should be 6th because counting is 4th. From the there, it may not happen, he may not come. 6th. আসতে পারবে না
কি হলো এটা দিয়ে দিন ওই 3:30 এটা ফিক্স আছে কি
I was trying to persuade Mr. Bhattacharya.
That you can go. There is a resolution.
But I could not prepare myself. I tell you, Lordship, I was requesting Mr. Bhattacharya to consent to an adjournment.
Yes. Which is refusing again. You can go. I have got no issues. So. You have taken a resolution. Time চাইছে তো
সোমবার
Sure, my lord, it will not be possible for him this side of the election.
No, somehow
it has got nothing to do with the constitutional post irrespective of the government.
No, because of the election
Matters, but election matters.
The election matters will be over. তাহলে আর একটু দেরিতে দিয়ে দিই সোমবার হবে না 28 তারিখ দিয়ে দিই up to 28 you will be free.
No, please keep it on Monday, but I'll come prepared by Monday.
Acha, learned advocate aid for the petitioner de facto complaint is present. Petitioner and the de facto complaint is present. Learned advocate aid general 6 on accommodation. List the bail application at 3:30 p.m. on 27th of April 2000.
The grand ballot. So we have filed a grand ballot praying interim ballot. In case the accommodation short will request for interim.
No, সোমবারের accommodation.
আর কি আছে?
Very difficult for me to oppose for Mr.
I'm grateful.
আর কি আছে? কেউ নেই তো কি করবো দেখে যান তা অন্যগুলো cancellation was fixed. কে আছে স্টেডিয়ামে কে আছে দেখি ওটা দেখি না একটু 431 টা দিন তো কে আছে একটাই না you were appearing তো না দেখি কোথায় গেল সৌমপ্রিয় রেশ তালুকদার
Malad will kindly peruse the Lordship's last order.
Affidavit in opposition হয়নি
Malad, Mr. Ganguly in this matter.
Ganguly Mr. Chaudhary appeared to. Where is the affidavit in opposition?
It is ready, Malad. We have just Malad.
Ready?
Yes. Difficulty is that Mr. Ganguly could not maintain. Mr. Ganguly could not go through the opposition.
Go through.
You are Friday or Monday if you let.
No, serve upon them.
Yes, we will serve upon them in advance, Malad. Just Malad till.
And our time dichina. File I am resuming. Affirm that. You will use and reply or no?
No, Malad. Your Lordship will kindly see your Lordship's last order, page 2. It will use an affidavit in opposition. I am supporting it. And Malad, we have also filed a cancel.
Affidavit in reply.
It will not be
We have already filed an application.
That then we have to prefer an opposition, my lord, if they have filed.
Whatever you have done, you do.
Where is your cancellation?
Because I had committed
That
before justice.
application file করেছে।
I had committed before justice Bose, but that I will file an application for cancellation of it. You also will find.
We have not been served with that.
Mr. Ganguly, you give a copy to them. Give a copy to the respective parties. Affidavit
opposition
বলেছি যে আপনি দেখতে
my lord, can we give it by Monday? Monday, because in the other matter we'll be using our affidavits also.
This is of 2024.
I understand, my lord. My lord, the order was passed in 2023.
You did not file the opposition from time to time. You are
Also, liberty was taken.
you are engaged now. Doesn't color changes.
Monday, 27th. 27th. I will also use an affidavit in the state matter also. My lord.
Yes, by 27th.
27th.
We are trying to get a soft copy by.
I soft copy,
What
but
is
physical
your
copy.
number?
You cannot irritate the hard physical copy. You will stay in your hand. Will we give you a soft copy?
Come give the number. এইভাবে order pass করে গন্ডগোল করে ফেলবে এরা।
আমি নাম্বারটা এক্ষুনি দিচ্ছি।
My passes order, I'm just giving the.
কবে আজকে ফাইল হয়েছে?
Let this application appear along with যে নাম্বারটা দেবে হ্যাঁ।
PRMM number.
Mr. Ganguly
কি করে হবে?
cancellation for the respondent, accused respondent number 2.
এটা দিবি কেন?
That
দিবি ছিল।
এখন the affidavit opposition submitted will be filed by tomorrow.
Monday, my lord, kindly.
Monday না ও শুক্রবার বলছে দেয়নি।
My lord, I have to see it.
না এখন তো খালি টাইম তো খালি টিউসডে হবে নাকি?
Yes, Monday, my lord. We'll give both on Monday. Because we'll be using an opposition in that also. So we'll give both on Monday.
If I decide, Mr. Roy will read now.
My lord, copy will be given today, if at all.
আমি সফট কপি পাঠিয়ে দিচ্ছি।
আরে সফট কপি তো হবে না। My lord, let it be on Monday, my lord.
যতটা এনার্জি নিয়োগ করে কিছু করতে পারেনি
I don't think he, let it be on Monday. He will use his reply if any by Wednesday or something.
Those dates have been mentioned over here by 17th of April.
Oh,
those everything has gone.
My lord, my fault. My lord, kindly on Monday. Right, on Monday we will give both the oppositions on that day.
কেন কি হবে?
এটা আমার দাও।
When did you affirm this application, Mr. Talukdar?
Well, this was in February or something, na?
এমনি 2 বছর চলে যায়, আর্গুমেন্ট ওখান থেকেই আরম্ভ করবে।
Oh,
because everything has changed.
16th of February 2024. The order was passed in October 2023.
So from time to time you have taken time for affidavit in opposition.
Well, we'll give it by Monday. Fine,
then that for this delay you will not argue on the email.
Well, some part I কি হলো দিলে না কিন্তু কপি
ভাই ব্রিফে ঢুকিয়ে ফেলেছেন।
এই তো
এটা এই এনে
রেকর্ডস মানে we have given দাদা এটা রেকর্ড করি না
ডিফ্যাক্টোকে দাওনি তো
দেব না।
CRM M 917 of 2026.
Now you after 2 years cancellation. CRM
917 of 2026.
And made sometime in 24.
Oh, affidavit in opposition has not been filed by the accused respondent number 2.
No, it was admitted today, so they have handed it over.
Admitted today, dada. Admitted copy.
তুই তো বললি রে বাবা।
না না, যাই তুই কপি।
Well, anyway, copy has been served on me today, so I undertake I will file it on by Monday.
It the accused respondent number 2 will also use the affidavit in opposition. In both the applications, the affidavit in opposition be filed by 27th of April 2026. Affidavit in reply is any.
3 days.
Huh?
3 days.
I will not file anything.
Affidavit in reply.
Reply.
Uh, তারিখে monthly list করে যাবে।
Fifth.
Monthly scan or
By 30th April 2026. Let the application be listed on 5th of May 2026 under the same heading fixed at 4 p.m. আর একটা জিনিস লিখে দিন as an application for cancellation of bail has been referred by the state will not use any affidavit in respect of the present application. Deep. Next. হ্যাঁ 432 এগুলো ডেকে দিন না পরে তারপরে বেলে চলে যাবো না কটা ডেকে দিন
Statement.
nobody.
I am for the petition.
Millet, I have the instruction to appear on behalf of the de facto complainant. So, Millet, if a copy of the cancellation can be served. Petition for the state.
State.
Petition is state.
No. It has been admitted.
আসছে না কেন
Appear করছিল তো last দিন এতে।
You have got to already, you have received already copy.
No, ও পাইনি। Haven't received. He is for the defect.
I am for the de facto. For the de facto.
Not today করে দিন এগুলো কাল
এটা কত 433
হ্যাঁ 433 আছে
না 434 বলে I am for the
What is this?
Verification of bail first time.
What matter?
Copy এটা থেকে নিতে হয় কি করে জানি না
420
क्या हुआ Rest applications क्या हुआ
first time.
Need to serve copy of the bail, copy of the application, copy of the application upon the opposite party number 1 to the office of the public prosecutor High Court Calcutta, and upon the private opposite how many parties? Upon opposite party number 2 by speed post with AD and file affidavit of service is on the next day 8 fixed for hearing. List the application for cancellation of bail in the month of June 2026. শুনুন রিল্যাক্সেশনটা আছে ডেকে দিন তো কেউ থাকলে করে দেবো নাহলে নেই ছেড়ে দিন নেই ছেড়ে দিন বেলে চলে আসুন পিটিশনার পড়টা না থাকে ঠিক আছে
Nandi was there 76.
No, not today, man.
78.
Seven. Are you come over here with the list?
78, my lord, substantially hurt this matter.
I have heard many things substance. This is a problem.
Kindly make it note to
সাহেব দেখো তোমার প্যানেলের অবস্থা কি হ্যাঁ দেখো না হ্যাঁ রেগুলারলি I will call the matters. Don't have to worry. চলো regularly.
It was 60. Today we have got a chance. Now they are.
No, now on regularly I will call. So I have to give আমাদের ডেকে যান both sides থাকলে থামবেন না হলে থামবেন না not today বাহ
79 88 হয়ে গেছে 79 হয়ে গেছে
80 বাড়ি চলে গেছে
he was behind
has he left for home left for home
he was sitting here because the next matters were taken
how can he ডেকে যান কিভাবে লিস্ট কমপ্লিট হবে আমি বুঝতেও পারছি
84, 84 1 and I am for the petitioner.
Yes.
I'm trying for not to relax.
Yeah.
25, 56,
I am for the petition.
57,
I appear for the statement. Yeah.
58, 9,
Okay.
91, Ninety-four, 95.
And if your lordship, I'm praying for adjournment.
Ready?
Lordship, senior is appearing.
Where is your senior?
Lordship, I am here, Lordship.
Steady. Ready?
Ready.
Now. 96 now. Yes, start.
Lordship, I'm in custody for more than 3 years. And Lordship, my custody, I was charged under section 376D, 376-2JL, 325, 506, Lordship. Lordship, it is very pertinent to mention here that the complaint was done by PW1, the victim girl's mother. Lordship, if we kindly see the statement of the complainant and when she was brought to cross, they are totally different, Lordship. There is discrepancy in the statement of the complainant's mother, basically the victim girl's mother, Lordship. It is also very pertinent to mention, Lordship, if Lordship sees the deposition copy.
All the evidences are over, Lordship. The next day is fixed.
Over?
Yes, Lordship, it's over.
Over.
Lordship,
3:30.
kindly take note, Lordship. The court is going empty, Lordship. He's in custody. The medical, Lordship, clearly shows that there has been no significant signs of rape, Lordship. Lordship, if you could kindly see the medical documents once, Lordship.
Not at this stage. Our 313 stage.
3:30, Lordship.
313 now. Can learned advocate appearing for the petitioner submit age that petitioner is in custody for 3 years. And there has been variance in the evidence of the mother of the victim girl as well as from the statement under section 154 of CRPC, which was deposed in course of the evidence, in course of investigation. Full stop. Unnecessarily, according to the petition, according to the learned advocate, petitioner is languishing in jail, and as there is no possibility of the case being taken to its logical conclusion within a reasonable period of time, petitioner may be released on bail on any stringent condition. Learned advocate 8 for the state submits that all the prosecution witnesses have been examined. It has been fixed for examination of the accused under section 313 of the Code of Criminal Procedure. Having considered the advanced stage of the proceedings, I am not inclined to release the petitioner on bail. Accordingly, prayer for bail of the petitioner is dismissed. Sure.
Grateful, Lordship.
Grateful, Lordship.
3:30 में release for grateful.
Yes.
नहीं, नाम दिए जो.
97, 98, 100, 101,
101, I am for the petitioner.
I'll just pray for a not to be.
102, 103, 104, 105, 106, 107, 108, 109, 110, 111, 112,
For the state in 12.
114, 115, 117, 118, 109, I am for the 120, 121, 122, 123, 124, 125, 126, 127, 128, 129, 130, 131, 132, 133, 134,
135, 137, 138, 139, 140,
140, I'm with state.
141,
I'm with state, 142.
143, 144, 145,
I'm for the state in 145.
147, 148, 149, 150, 151, 152, 154, 155, 156, 157, 158, 159, 161, 162, 163, 164, 165, 166, 167, 168, 169, 170, 171, 172, 173, 174, 175, 176, 177, 178, 179 to 203.
180, my lord, I for the de facto component, my lord.
State.
So, state make.
No matter.
My lord, kindly make it not this week, my lord.
No, not this week, Baba.
We are keeping on Friday, my lord.
Would you speak with the state?
But 180
180?
I need the direction for service of the POCSO.
Accused.
I need to serve.
Cancellation. Cancellation ही नहीं है लकी पर.
Bail to 180.
Bail to
180.
This has come under the heading bail.
This is cancellation.
This is the cancellation.
Petitioner is directed Petitioner is directed 189. Petitioner is directed to serve a copy of the application on the office of the public prosecutor upon the opposite party number 1 to the office of the public prosecutor High Court Calcutta, and upon the opposite party how many?
1.
Upon the opposite party number 2 by speed post with AD and file affidavit of service on the next day 8 fixed for hearing. Let the matter be listed under the heading cancellation of bill in the monthly list of June 2026.
Not far. Without hearing, we will decide.
Daily করছে না লোকে ক্যান্সেলেশন করতেই হবে 500 বিল বাকি হয়ে গেল কি করবো রোজ ডাকছি কি টাকা দেখে
ক্যান্সেলেশন অফ বিল নাম বললো কি করে স্টেট
তো হতেই পারে কি আছে আমি বলছি 18 না
দেখে আদি
My lord, item number 21, my lord.
Yes. Where is your brief? Where is your brief? Huh? CP नहीं ऐसे वो मामला होता है वो है.
My lord, the sections are under my lord for a traffic act and my lord.
What?
My lord,
What are you wanting?
my lord, kindly a direction for service can be
To which item?
My lord, 21, my lord.
221. What is the CRM number?
21.
My lord, here.
जाने ही हाँ
895.
My lord, 895, my lord.
895.
My lord.
Yeah, Bindeshwar Thakur to. Petitioner is directed to hand over a copy of the application upon the learned advocate appearing for the state. Learned advocate for the state would, through the officer in charge of the concerned police station, FAX service is on the private opposite party and submit a report before this court enclosing in the acknowledgement. List the let the application retain its position in the list.
129.
223.
223 আছে দাঁড়ান 223 rules for the state.
223.
চলে গেছে বাড়ি.
Item number 233.
Worship, on the other day, it was also not today.
So do then start দেখি বার করো দেখি. Yes, sir.
233, my lord, I am for the petition.
Somebody is doing the matter. You have got to keep patience.
Worship,
223 file the বার করো.
Worship is in custody for more than 423 days.
Under which section?
111, 316, 318, 319.
We have been arrested for what?
The cybercrime matter, Your Lordship.
তাহলে cybercrime matter দেখি 111 আছে তো
Yes, Your Lordship.
দেখি দাও ফাইল দাও
But till date, commitment has not happened in this matter, Your Lordship. Till date, commitment has not happened in this matter.
What is the material according to charge sheet you have enclosed?
Yes, Lordship. The charge sheet
What is the
filed-
material against you? Where is the charge sheet?
Annex, Lordship, page 11, charge sheet.
Page 11.
Jyotish.
How many cases are there against you?
Other than this, there are two other cases. But in this matter, Your Lordship, till date, commitment has not been happened.
I'm directing. So learned advocate 8 appearing for the petitioner submits that the petitioner is in custody for
23 days.
From 120 one year
1 year 3 months, Your Lordship.
35 has for about 1 year 3 months. Charge sheet has already been submitted and according to the learned advocate 8 এখানে 18-4 কি 10 বছর হয় এখানে 18-4 কত কমিটমেন্ট বলছে না কেন to 5 বছর why should commitment be there which section
Stands 111 subsection 2 316
আরে না which section is above 10 years
318 subsection
which 318 which subsection
sub 2 subsection 2, Your Lordship.
Subsection 2 is for 3 years. 4 is for 7 years. Why should it be committed? Commitment চাইছে বলে দিলে মুশকিল পড়ে যাবে ওরা 111 to
10 বছরের উপর কি আছে
111, Lordship. 111.
হ্যাঁ 111 to charge sheet under 111 to
Charge sheet has already been filed at 27/5/20.
চার্জ শিট কোন সেকশনে ফাইল হয়েছে
111. Page 40.
কি বললাম ঠিক আছে and the case has till date not been committed to the court having to the sessions court full stop to the jurisdictional court which is empowered to conduct the trial full stop learned advocate for the state opposite is a prayer for bill. I have taken into account the materials appearing from the records full stop it on a query from the court learned advocate for the petitioner submits that there are 2 other cases against the present and petitioner full stop having considered the stage of the present proceedings and the antecedents of the petitioner, I am not inclined to release him on bail. Gallo. Next, however, the learned trial court, any person absconding.
No, Lordship. There was a co-accused, he was granted bail.
No. Nobody. So why it has not been committed? Have you been supplied with the copies? Other investigation is going on. Huh?
Lordship.
When is the last order sheet you have enclosed?
The rejection order, Your Lordship.
It's of February. Full stop. If there are no other impediments, learned magistrate in season of the case would at the earliest take steps for committing to the case to the appropriate court having jurisdiction. Since the charge sheet reflect that the prosecution has investigating authority has charge sheeted amongst other sections also under section 111 of the BNS. Full stop. With the aforesaid observations, at this stage, CRMM 897 of 2026 is dismissed. Next, man.
For the petitioner, my lord, item number 233, my lord. My lord, all other co-accused are on bail, my lord. My lord has passed last order on 16/4/2026, my lord. I'm on the same footing, my lord. I'm in custody for 1 year 9 months.
কল করুন পূর্ণিমা পুরো বাঞ্চটা দিন ওখানে ওর আগে কেউ থাকলে সে তো নেবে Who is there in 233?
My lord, I passed the last order on 16/4.
I will reject the bill, as simple as that. You pressure me, I'll reject the bill. Without hearing the state, I will not grant bill.
26.
To 98.
State is there, ready.
Also,
Service. Two koto? 80?
285. Section 12 of Proceeding.
285. Petitioner is directed to hand over a copy of the bail application to the learned advocate appearing for the state. Learned advocate for the state would, through the officer in charge of the concerned police station, if a service upon the private of the party and submit a report before the court, enclosing the acknowledgement. Full stop. Matter be let the bail application retain its position in the list.
এটা কে জেনে তাকে সার্ভিস করতে টিপি অফিস থেকে জানবো এখানে লেখা নেই এন্ডোর্সমেন্ট নেই
Item number 274. Service is not completed.
274 এক অর্ডার করে দিন নেক্সট ফলো করো
থেকে জেনে তাকে দিয়ে দিবি কত
299 থেকে 324
For item number 290, Mr. Amitav Ghosh is the advocate on record. His mother has died. Kindly adjourn for 2 weeks, my lord.
Tomorrow come. I'm not doing anything to anyone. Okay. ডাকুন কি আছে
আমি 316 মানে ডিফেক্ট
তারপর দেখে তাড়াতাড়ি আর কি আছে 325 থেকে 48 করে দিন
5, 48.
কি আছে
73. 62 are for the petitioner.
কক্সো কি করে হবে কেউ দাঁড়াচ্ছে না
368 I am for the petitioner মানে let the service in respect of the victim that forwarded
what section
মানে POX 368 রাম মন্ডল yes
বাবা রে বাবা
রাম মন্ডল
পিটিশনার নামও যেমন টাইটেল হচ্ছে না একই অর্ডার করে দাও পক্সোর একটা হ্যাঁ
I will serve
নেক্সট
সোনালী দাসকে দিয়ে দিই সোনালী দিয়ে
হ্যাঁ নেক্সট চলো
দেখে তো
399 to 423.
আরে এগুলো তো 25 আরো আসবে তো
425. 426 to 430.
কোথায় গেল আর কিছু বাকি আছে আর বাকি আছে ফিক্স 163 শিওর তো ইওর ম্যাটার তো একটা বক্স অর্ডার করে দেবে সার্ভিস
কত
166.
ওদের কাছে নামগুলো একটু নিয়ে নাও না ম্যাটার গুলো থেকে। হ্যাঁ, সার্ভিসে যেগুলো আছে না স্টেটের একটা লিস্ট নিয়ে নাও, কারা কারা আছে একটু দিয়ে দাও। চলো, হয়ে গেছে।